All right, good morning, everyone. I'd like to call to order the Judiciary Committee a committee meeting actually for March 1st, 2024. Time is 10:02. Any remarks from my co-chair or the ranking members? Seeing none, we're gonna jump right into our agenda. So before us today, we have two proposed significant settlements. We are going to start with a presentation by the Office of the Attorney General regarding the stipulated agreements that are on our agenda. Before us, we have Deputy Attorney General Eileen Meskel, and she will introduce the team who's with her. Deputy Attorney General, welcome, and whenever you're ready.
Good morning, Senator Winfield, Representative Sastrom, Ranking Members Senator Kissel, and Representative Fishbein, as well as the other distinguished members of this committee. As Representative Sastrom said, my name is Eileen Meskel. I'm the Deputy Attorney General, and with me today from my office is Kara Pissarro, our Chief of Staff, Josh Perry, who's on the end, our Solicitor General, and Terry O'Neill is the Chief of our Public Safety Section. And as indicated, we're here today pursuant to Connecticut General Statutes 3-125A to seek approval of a settlement in the amount of $25.2 million in the federal court case of Birch Henning versus Town of New Milford et al. The plaintiffs in that case, let me just clarify, they were originally filed as two cases consolidated as one case, are Ralph Birch and Sean Henning, and they filed civil rights lawsuits in 2020 against the Town of New Milford, multiple municipal police officers, multiple state police officers, and Dr. Henry Lee of the State Crime Lab. The underlying facts, which I'm going to give you a pretty broad overview, but of course we're happy to answer any questions, are as follows. In December of 1985, a man by the name of Everett Carr was stabbed to death in his home in New Milford. Members of the New Milford Police Department and the State Police Western District Crime Squad responded to the scene to investigate. In the ordinary course of securing evidence, they found a white hand towel in the upstairs bathroom, and visible on that towel was a small reddish stain that appeared to be blood-like. That towel was secured in a bag and seized by the evidence officer. The subsequent investigation focused on burglaries in the area, and because of that, they focused on these two individuals because, in fact, they had admitted to committing burglaries in and around that area. Ultimately, throughout the investigation, the police got statements from other inmates that knew Mr. Birch and claimed he had confessed to being there, but didn't provide any other details of the crime. In addition, the police obtained a statement from Mr. Henning's grandmother that indicated he had a phone call with her and had confessed also to being at the scene. No forensic evidence was ever found that linked these two plaintiffs to the crime. Both were arrested for murder and subsequently tried. At each trial, Dr. Lee of the State Crime Lab testified that he tested this white hand towel and the reddish brown spot for the presence of blood, and that it had tested positive. He was not asked whether the test was presumptive or confirmatory by anybody there, but he also testified that there was no DNA evidence or other evidence in terms of forensics that tied these two individuals to the crime. Nevertheless, the prosecutor, during closing arguments at the trial, referenced Dr. Lee's testimony and used the fact that there appeared to be, or that there was a presumptive or some type of test that confirmed blood as evidence to show why there might not have been evidence on the two plaintiffs. So his argument at closing was the reason there wasn't anything was because they went up and cleaned up in the bathroom and used this small hand towel, despite the fact that there was very small spot on the towel and a large amount of blood in the home. And so it was really a weak argument. 25 years later, in 2015 and 2016, there was a second habeas trial for each of the plaintiffs. And their argument and evidence was introduced that indicated that the white hand towel was never actually tested and that the spot on the towel, which had then been tested, was not in fact blood. The claim was pled as a Brady violation against the state's attorney's office. They argued that the prosecutor wrongfully failed to disclose to them that the towel had not in fact been tested, and that the failure to disclose this fact violated their rights. The trial court rejected those arguments, but then up on appeal in the Connecticut Supreme Court in 2019, granted a new trial for each of the two plaintiffs because of their finding that the testimony could have influenced the jury to convict these two. And that they agreed that the testimony, since there was no evidence that the towel had been tested, that the testimony was incorrect. They did not impute any intentional motive or intentional testimony by Dr. Lee, just that the testimony was incorrect. And the Supreme Court, as I said, vacated that. It went back down. The state's attorney's office decided not to prosecute, and the charges were dismissed. And as I said, in 2020, the two actions were filed. In June of 2022, each of the plaintiffs filed a claim with the claims commissioner under our new claims statute. And but at the same time, the federal court was proceeding through discovery and all of the normal course of litigation. In July of last year, Judge Bolden, in the federal case, issued a memorandum of decision in response to cross motions for summary judgment, and found that Dr. Lee had in fact wrongfully fabricated the incorrect testimony. Thus, for purposes of that litigation, Dr. Lee was found liable, leaving us to only have a hearing in damages as to him. And just a reminder, we had 5 other defendants on the state level, which were 5 state police officers. But they were not found liable at the summary judgment, but that case still would have proceeded. They were not granted judgment either. We took an appeal of that decision to the Second Circuit, but during that process, we engaged again with the plaintiffs to discuss settlement. The plaintiffs had requested initially $60 million or $30 million each. And through our research with one case that we had already dealt with, and through cases in other states, there was not a lot, but there were some, we came to a resolution with the plaintiffs for the number that I mentioned earlier, which is 25.2 million or 12.6 each. That resolves the federal court action, our appeal, and the claims commissioner actions as well in the settlement. And, you know, I'm happy to talk about, if you want to know, what some of the other cases that we looked at. But we respectfully, obviously, ask that this settlement be approved. And we feel that that resolution is a good resolution for all parties involved. Thank you.
Thank you. Questions from the committee? Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney Metzger, Deputy Attorney General. Thank you so much. Good morning. I first of all want to thank all of you for meeting with me earlier regarding this particular matter. It was very elucidating. And give my very best to our friend and colleague, the Attorney General, William Tong. I feel very comfortable personally regarding this settlement, but part of the rationale for that, and if you could perhaps go into a little bit of detail regarding this, our surrounding states, in particular New York, they ascribe a certain value for in unlawful incarceration per year, sort of a rule of thumb. And I also am concerned about what a jury may come in with. So, you know, I think this settlement is fair, but also good for the state of Connecticut as much as any of these things can be good for the state of Connecticut, because I'm concerned that if a jury came in light of what's happening in other parts of the country, and as I noted, New York, could be substantially higher than this. And also, we are resolving the claims commissioner aspect at the same time. So if you could just clarify that a little bit, I think that might reassure some of my colleagues on the committee as well.
Sure. I think, and I'm going to ask Terry to jump in a second, because I think he looked at those New York cases. And I think it's fair to say that Connecticut, we haven't had that yet in terms of a full jury trial. That's correct. So what we did, just for Connecticut's purposes, we did have another case that we looked at, and Terry will talk about the New York cases in a second. We had a case in which an individual had a settlement with the city of New Haven, and I have that here. And that was one case we used as a benchmark. He was awarded or entered into a settlement, I'm sorry, 9.5 million from the city of New Haven, and then filed a claim with the claims commissioner and was awarded another $5 million for wrongful incarceration. And so that was one benchmark we used. I'm going to ask Terry, and that was approximately 19 years of incarceration. So I'm going to ask Terry to talk about the other cases that he looked at.
I'm happy to. The prevailing trend in the state of New York, which is a little bit ahead of us, seems to be calculating damages, Senator, at roughly $1 million a year. And when we worked off of that benchmark and coupled it with our recent experience with the New Haven situation that the Deputy Attorney General just referred to, our concern was that not only would we be exposed to $1 million, but possibly even more, but certainly that the courts would affirm an award in that amount. And when you multiply this out by what was going to be 27, 28 years of incarceration, we could get into some very, very serious numbers very quickly.
Right. And so I just think that point has to be underscored, because to me, and again, I don't think that we should react like a knee-jerk reaction when Massachusetts or New York does something, or California. Obviously, we're an independent state. We go our own way. And I'd like to think that the folks in Connecticut are somewhat frugal and mindful of tax dollars being spent. But even just using the $1 million as a benchmark, we are well below what this could end up as. And so even if 1 million is a high watermark, there's a lot of territory in between where this is being proposed to settle at and what a jury could come in with. And it also resolves our claims commissioner matters at the same time as well. I have known Dr. Lee for many, many years. I consider him a friend. I have a local cable show where I've had him on more than once. And I don't look at this necessarily as some sort of disparagement of him and what he did. Forensics was far different back then. And I know he was upset about the outcome of all of this, but this has nothing to do with that. This has to do with these claims having a life of their own and the exposure of the taxpayers to these claims. And these claims aren't going away. It's not as if you could, dig in your heels and try to say, no, we're not going to pay a nickel. That's not going to be the end result in anybody's imagination. So I am always hesitant to give our imprimatur to these settlements, because I want a rigorous defense for the taxpayers and fairness. But I think that you've done an awesomely good job, given the cards that you were dealt and the cards that the state of Connecticut was dealt. And if you ask anyone what they would pay to have years of their life spent in prison, it's really unfathomable. And so I appreciate all your hard work, all of you. And again, give my thanks personally to the Attorney General. You guys are just the best attorneys that the taxpayers could have, and I appreciate all your efforts. Thank you very much, Chairman Staffstrom.
Thank you very much.
Representative Fishbein.
Thank you, Mr. Chairman. The system failed these two young men who were 18 and 19 at the time. Failed on 3 different planes at least. Dr. Henry Lee's testimony, the Supreme Court held back a little bit on accusing him of falsifying evidence. They didn't do that. But at the end of the day, Dr. Lee said that his initial test, the conclusion was that it could be blood, and blamed the state essentially for not asking him to test further. That was a failure in the process. The police failed these two young men. When you read this case, every winter I go and buy John Grisham's new book, which, over the years has dovetailed into these areas. And I know that, John sits on the Innocence Project's board. But in this case, something that wasn't mentioned was this was a cold case. The murder happened in 1985, and the case sat dormant for about a year. And in the interim, the investigating officer says to another officer that at the initial interrogation, one of these young men said, when he's looking at a photograph, he may have said, "There's the bathroom," which indicated some knowledge of the interior of the room, of the home and that kind of stuff. That statement didn't appear in the initial report of this. But the officer who he told it to evidently had taken on the case, and that now reviewing officer, I think the report, the case indicates strong arm the initial officer into amending his report to now include that statement. Statement that I believe at trial, the officer testified was so compelling in reaching this conclusion. Now, you would think that an officer who initially heard that statement would have included that if it actually happened. So the police failed these two young men. And third, the public defender's office failed these two young men because there was significant exculpatory evidence here. The relation of, I think it was the daughter of the decedent, Ms. Colombo, had lied to the police about where she was at the time of the murder. She also apparently, allegedly, had called the dispatcher and made an excited utterance, something to the effect of, "Oh my God, he's got a knife." Now that's in the singular. That shows some knowledge of perhaps the actual assailant. We have somebody who is stabbed 27 times. Now, all you got to do is watch a couple episodes of CSI to tell you that that's a crime of passion. Two young men who are 18 and 19 burglarizing a home, who are met by somebody, the homeowner, the occupant, are more than likely going to be scared and looking to, just stop someone from stopping them. A couple times, person goes down, they're out of there. Think about that, 27 times, insert out, 27 times. There is some level of personality to that. The two young men had actually stolen a 1973 Buick. They had recently went up to New Hampshire with it. They were basically living out of the car. Car was full of trash. But there was no blood evidence in the car. It was quite obvious that they had not cleaned the car because all the trash was in the car. You stabbed somebody 27 times, and Dr. Henry testified that there was probably blood everywhere. There's going to be some evidence of blood. But at the trial, the public defender's office really just glossed over most of that, and some of it didn't even get mentioned at all. That was a failure, in my opinion. So then these two young men get sentenced to 55 years. And they served basically 2/3 of it. And, to the thanks of the Innocence Project, which is another issue. I was talking with the chair the other day. Currently the Innocence Project falls under the public defender's office. And I think that's a problem. Because, they're supposed to be neutral and look at the case in its totality. And when you have one of the sides, especially in this case, that's then being evaluated internally, there is no neutrality. And in this case, the actual facts show that the Innocence Project realized partially through their investigation, their review of the case, that they had that conflict. And the Centurion project took it over, that we've worked with before, and I've read the founder's book and all that stuff. There should be a divestiture at some point. You know, they should be under a different agency, and, you know, we can deal with the funding, all that stuff. But that brings me to a question. I know, and I thank you for meeting the other day. What is the tax consequence? I know you don't give tax advice, but I know we talked about it the other day. Does anybody know what is the tax consequence of this award?
I do not know. Do you know, Terry?
It's been my experience, Representative, that we pay this through the comptroller's office, right? And a 1099 is issued to each of the plaintiffs, but that it's treated as compensation for a personal injury or loss. And I don't know that, for example, I can tell you that the state does not withhold taxes from the payment.
Okay, I just, I think it's a little perverse to take away somebody's liberty, the government, put them behind bars, have them found to have been wrongfully put behind bars, give them an award, and then to say, give us money back. So I would hope that it is not a taxable event. If it is, I'd like to know, because God willing, if I'm here next session, putting it in, because it shouldn't be. I think that's all that I just, you know, I know I read about these young men when they, you know, the case came down, and, you know, we hear a lot of times that, you know, I'll throw it out there. We hear a lot of times that certain members of our community, the system is slanted against them because of their race. And I do recognize certain aspects of that. But I will point out that these two young men were white. Not saying, you know, I'm just pointing that out. That's all. It's a tragedy what happened here. I just, you know, anyway.
Rep. O'Day.
Thank you very much, Mr. Chair, and thank you to you all for your dedication work in the state. I know Attorney O'Neill from back when we practiced together in private practice, and obviously have the utmost respect for him personally and all of you for your service. And I don't have the knowledge of the case that the chairs and ranking do on this matter, and I have not gone through it. So forgive me if I'm asking a question that is obviously naive or wrong based on all the documents. But from what I've gathered, and I heard the good ranking senator knows Mr. Lee, I do not know him. But did the court find, I mean, it sounds to me like he lied under oath based on the information that I have or have heard and seen briefly. But the court didn't, am I accurate? The court did not find that he lied under oath. Is that true?
Do you want to address it? I think Josh Perry will address that. Thank you.
Thanks for the question, Representative O'Day. And I should explain my role in this. As the State Solicitor General, my team handles every appeal that the Attorney General's office is involved in. And so after the summary judgment motion came down, we really dived in deep and reviewed the entire record here. And no is the answer. There was no finding that that Dr. Lee lied under oath. It's true that the Supreme Court used the word fabricate, but they were very clear that they were using that as a term of art and that they were not imputing intent to him. What they did find was that his testimony was counterfactual, But of course, that's not the same as saying that he knew it was counterfactual, right? But there's no doubt that the finding by the Supreme Court was, and this was based on a stipulation by the state's attorney, that the testing had not actually occurred on the tower.
Because one of the questions I have is are any of the people who failed these individuals, whether it was the officers, members of the court system, were anybody found to have intentionally committed misconduct of a nature such that they can be held financially responsible in some way, shape, or form, or otherwise prosecuted themselves for misconduct? I don't know the answer to that. I'm wondering if you all found any evidence of that.
So we did not. We did not find any evidence of intentional misconduct. Of course, the Attorney General's office conducts an inquiry when we're defending people in their personal capacities to determine whether we can and should indemnify them. That's part of our ethical responsibility. And we determined that it was indeed appropriate to continue to indemnify Dr. Lee and all of the investigating officers, which is not to contradict the points made by Representative Fishbein. It is to determine that we believed that indemnification was appropriate. And in fact, this settlement agreement explicitly acknowledges no wrongdoing. I will say we continue to dispute some of the determinations made by Judge Bolden in his summary judgment determination. We took that appeal, and I'll take responsibility for signing off on that one. We took that appeal because we believed it was a meritorious appeal. We also ultimately believed that it was in the best interest of the state of Connecticut, that it was the fiscally prudent thing, and that it was the right thing on the equities to resolve the case.
Thank you for that, and I greatly appreciate it, and trust you all implicitly on that. So thank you. And did I understand correctly that this payout is consistent with the settlement amounts for other wrongfully incarcerated individuals throughout the country? This is within the realm or the range of what has been paid by other jurisdictions and in Connecticut?
Yes.
Okay. And just for the sake of anybody listening and those members on the committee, I do handle cases in which settlements can arguably be taxed. And what typically happens is a lot of good plaintiffs, well, I shouldn't say it, a lot of lawyers, plaintiffs' lawyers, will not plead loss of income so that there is no tax consequence or payout. And even if they do plead loss of income, that the settlement can be based solely on pain and suffering type damages so that there are no tax consequences. Mm-hmm. And I would echo the comments of my good ranking member. Hopefully, we are assisting, not in any type of tax fraud, but certainly in assisting these individuals in framing the settlement, which is done all the time, that the payments are for pain and suffering such that there are no tax consequences. I assume that has probably been discussed at some length. I'm not going to ask you to respond to that, but just for the good members of the committee, that's typical and it's done. And so, and it's done in good faith. So there's no problems with that. So, look, this is a very troubling matter. I appreciate that the state put on you all in the position to resolve this, and I'm going to vote in favor of this, and hopefully my colleagues will also join me in voting for this. And I would hope that we do something to address putting the Innocence Project maybe outside the realm of the Public Defender's Office, because I do think that should be considered. So thank you to you all, and thank you to the good chairs and ranking.
Thank you. Representative Blumenthal on remote.
Thank you, Mr. Chair. And I apologize to everyone for not being there in person. I'll try to read, just kind of want to make a brief statement about my impressions based on your testimony and for reading about the case. first of all, I have the utmost confidence in the very skilled and experienced attorneys who defended this civil case. And that you vigorously defended it on behalf of the state. And so I'm very confident, not only based on your testimony, but also based on the fact that before I was in the state legislature, I also worked with the plaintiff side. These sort of matters that you're correct that the risk for a verdict is significant in terms of the verdict. It could be much higher than this one. In a case like this one where so much time's been served. Additionally, I just want to make a brief statement. Representative Fishbein, the distinguished ranking member, talked about the facts of this case in detail. One thing that I think we always have to think about is when we look at these sorts of settlements is the ability and the duty under certain circumstances to take away someone's liberty is a sacred one. And when the state makes mistakes in that regard, when it makes significant mistakes in that regard, those mistakes are costly not only to the individual who's incarcerated, but also to the victims who don't receive true justice, also to the state itself, and our legitimacy and ability to prosecute such cases in the future. And so I think as we consider this proposed settlement, we should bear in mind that we have a duty not only to defend the state's taxpayers, but also to do justice. And the state made a mistake here, a big mistake here. The settlement is a significant amount of money, but it is one that hopefully will do some justice in this case. And so I thank you all for your work defending it and hopefully helping us provide a just outcome here that can provide some justice. So thank you to all the attorneys for today, for your presentations and for
Further questions or comments from the committee? Representative Hall, first time.
Thank you for being here today, and please stop me if this question is inappropriate, but because we're looking at the settlement in this case, and I certainly plan on voting for it, how does this set the state for future cases that Mr. Lee has testified on? As we all know, he's one of the most knowledgeable forensic scientists really in the world, and has testified probably hundreds of thousands of times on hundreds of cases. So my question goes to, does this open the floodgates for every single possible trial that he's testified for or against?
So I think, while I understand the question, it's hard for us to answer that question because obviously we aren't the state's attorney's office and or the public defender's office. We're only here on the civil side. What I will say, though, is, of course, I understand that concern. The decision by the Supreme Court came out in 2019. And so I would presume that the state's attorneys and the people impacted would have reviewed that. And what I will say, it's 2024. This is the only case that involving Dr. Lee that we are handling. So to that extent, I can just assure you that we don't have, that doesn't mean, I can't promise there won't be more in the future, but this is the only one we have involving Dr. Lee. And that, as I said, the original decision, by the Connecticut Supreme Court was in 2019.
Okay, thank you for that. And I appreciate it. Thank you, Mr. Chair.
And I'd also note, just for the record, that the settlement agreement does contain a no admission of liability clause. And so while we are settling this today, and while certainly I think, as the ranking member pointed out, probably most, if not all of us on this committee could find objection to certain state action or activity taken by state actors. To be clear and for the record, the state is not admitting fault through this settlement. Is that correct?
That's correct. Thank you.
Representative Fishbein for the second time.
Thank you, Mr. Chairman. I just want to, when I said that the police had failed these two young men, there's another portion of facts I just wanted to lay out there for the general public. So, in sitting up here, there's many things that come across my desk that wouldn't have ever come across my desk if I wasn't sitting up here. And one of the things that we talked about, I think last session, was jailhouse snitches. And in this case, there was, in my opinion, the manipulation of a jailhouse snitch. Before these two young men, well, of course, of the investigation, one of the investigating officers went to visit the cellmate of one of these two young men because they had been picked up on the burglary stuff. So they're being held on the burglary stuff. And during the course of his speaking with the cellmate, he takes his investigatory file, opens it up, and leaves it for the cellmate to review, and then asks him the questions. In which case the cellmate says, yeah, this guy told me, about all of this stuff about what happened at the murder scene in exchange for a more lenient sentence. That's the kind of stuff you see on TV. It actually happened here. Should never happen. And it's changed my perception on so many planes of all of these cases, really. So I just wanted, because the general public doesn't really read this stuff, but I think it's really important to know what actually happened to these two young men that is very tragic. Thank you, Mr. Chairman.
Further questions or comments? Representative Day for the second time.
Thank you, Mr. Chair, for the second time and last, I promise. Along those lines, my question is lessons learned. Now, I don't want you to divulge, obviously, conversations you've had with your clients, essentially, but hopefully the state has had some lessons learned in this case. When I handle cases, I often have conversations with my clients afterwards about lessons learned to make sure it doesn't happen again, whether it's a truck accident that I've handled, negligence in a medical malpractice case. There are lessons learned that the attorneys have conversations with their clients. I hope and pray that there were lessons learned in this case that were relayed to the involved individuals and entities such that in whatever manner possible, things like this won't happen again, or we can do better to prevent these from happening. Were there lessons learned? Just a yes or no, and hopefully there were conversations had. Just a yes or no. I don't need to know any details.
So I'm going to say every case there's lessons learned, right? As a lawyer, I believe that that's true. In terms of conversations, I'll let Terry answer, but what I will just respond to that is that by the time we got the cases, none of our individual defendants were still working, or at least they working for the state. You have to remember this happened 30 years ago in a different environment. So it's a little challenging for us, again, because we don't work on the criminal side, right? Versus when we work directly every day and every week and every month with our state agency. So that's the challenge there. I would presume that in 2019, there were certainly conversations at the state's attorney's office, right? And through that process of how it got there. I don't know if you, Terry, have anything to add to that.
Yes.
Yeah, okay, great. Because I was on post, which was one, it used to be called MPT, Municipal Police Training Academy. And I was a public member of that. And we did have conversations when things would come up about how training should be altered, and how officers can be reprimanded and disciplined. And so presumably that has happened and basically I just got a yes from my good friend, Attorney O'Neill. So I'm glad to hear that. And I hope those that were involved in making sure or overseeing this, or who are in charge of it now, are listening and make sure that we do as much as we can, make sure it doesn't happen again. So thank you.
If I may, to that point briefly, Representative, remember, we're talking about facts that were developed in the early to mid 1980s, trials that occurred roughly in the late 1980s, with crime techniques, practices, procedures, lab techniques, practices, and procedures that were of a 1970, 1980s vintage. They were then scrutinized under a 2010, 2015 microscope with better development and better practices. And that it took so long, while a tragedy perhaps, certainly yielded eventually the right result because of the evolution, not just in the law, but also in practices and procedures. And I think we need to keep that in mind when we look at these actual innocence cases.
Good point. And I appreciate that. Thank you very much, Mr. Chair.
Senator Harding.
Thank you, Mr. Chair. And so thank you for coming today and for your work on this. And I just, looking at it from a financial and numbers perspective, because ultimately this is the taxpayers, dollars we're talking about here, and all of you understand that. Again, just reiterating, this is your analysis that this is the right settlement from a justice perspective, obviously, but also from a financial perspective for the people of the state of Connecticut. Because that's something that I think we also have to grasp for each of our constituents when we make a vote on this.
Absolutely, Senator. And that's, we consider all the factors, obviously, when we look at settlement and when we enter into settlement. But yes, we try to consider everything, obviously.
Thank you.
Just on that point, if you could just clarify sort of where the funds for this come from to pay this out.
I believe they come from the adjudicated claims fund. Yeah.
Further questions or comments from the committee? Further questions or comments? If not, I just one question I had that didn't come up is noticed the underlying case captions are versus the town of New Milford, and New Milford is not a party to the settlement agreement before. So do those claims continue on? Has New Milford already settled? What's the status with respect to the claim against the town?
The claims continue on. If you want some detail, I'll let Josh answer, but they did not settle along with the state. It's the town of New Milford, and I believe some New Milford police officers who were sued as well. I believe they have an appeal from Judge Bolden at the Second Circuit. Is that correct, Josh?
That is right. Yes, they have a qualified immunity argument that is now up on appeal at the Second Circuit, but they did not resolve the case alongside us.
Okay. So I just want to wrap up by just thanking you for bringing this to us, for resolving this. As I mentioned, obviously there is no admission of liability in the settlement agreement, but certainly I share the concerns, I think, expressed by a number of my colleagues here today about what happened to these two kids, two young men who have essentially had their lives taken away from them. And there is frankly no amount of money that we can pay to give these kids their lives back. I think as we settle this case today and we talk about lessons learned and where we go, and certainly being in a different era, one of the things I'm struck by and reminded of as we settle this is the danger in imposing very, very lengthy sentences on kids, on 18, 19-year-old kids, even for what is believed to be horrific, heinous crimes at the age of 18, 19, and essentially taking a kid's life away from them with no ability to seek an ability to make atone for mistakes they made as a kid, for chance to move on with their life. And it is a reminder that very, very lengthy sentences for kids we need to be judicious in that, and not end up in these types of situations. So, thank you all for being with us. with that, Madam Administrator, we will move on. I think we need a senator to make a motion to approve Senate Resolution number 5, which is a resolution approving the stipulation of the settlement in Ralph Birch versus the town of New Milford et al. And Sean Henning versus the town of New Milford et al. This will be a joint favorable to approve. I need a Senate motion.
So moved.
I have a motion from Senator Winfield and a second from Senator Kissel. Madam Administrator, please call the Senate roll.
Roll call vote on Senate Resolution 5, Winfield,
Winfield, yes.
Flexer, Kissel,
Yeah.
Gaston, Harding, Lesser, Mar, Miller, Sampson.
Thank you. We will hold the vote open until noon for folks to get votes in. All right, moving on to item number 5 on our agenda. I will entertain a joint favorable motion to approve House Resolution number 5, which is the resolution approving the stipulation of the settlement in Ralph Birch versus the town of New Milford et al. And Sean Henning versus the town of New Milford et al. I need a House motion and a House second. I have a motion from motion from Representative Fishbein and a second from Representative Porter. Madam Administrator, please call the roll.
Roll call vote on House Resolution 5, Staffstrom,
Yes.
Quinn, Fishbein, Blumenthal,
Blumenthal votes yes.
Callahan, Conley, Curry, Delaney,
Delaney in the affirmative.
Dillon,
Dillon, yes.
Doucette, Dubitzky, Elliott,
Elliot, yes.
Gilchrist, Godfrey, Paul,
Paul, yes.
Hayes,
Yes.
Howard,
Yes.
Johnson,
Senator Johnson votes yes.
Khan, Labriola, O'Day, Osborne,
Osborne votes yes.
Havelock D'Amato, Porter,
Porter votes in the affirmative.
Sims, Beach,
Beach is a yes.
Walker, Wilson.
And votes in the affirmative.
Thank you.
All right, announcement of our next meeting. That would be today at 1 o'clock. So everybody enjoy a little lunch break. We will be back at 1 o'clock for a public hearing. Also, folks, just know we are getting into sort of the meat of our committee process. So please be aware there are public hearings scheduled for every Monday, Wednesday, and Friday between now and our JF week. And so please be on the lookout for agendas. And with that, we stand in recess until noon when this meeting will close, and then we'll be back with public hearing at 1 o'clock.
Application name is still disputed, but we believe it can be resolved. It's going to take it.
Kirsten, are you there? No.
And regarding.
Kirsten, I'm sorry, there's some overtalk. Can I, are you ready for me?
Yep, if you can hear me, okay, Representative Callahan, how would you like to vote?
I would like to vote yes, thank you.
All right, you're all set. Thank you.
Thank
Senator Sampson?
Sampson is yes.
All right, you're all set. Thanks so much, Senator.
Thank you very much, Kristen.
Conley?
Conley is yes.
Thank you. Representative Johnson, do you have a question?
I just want to be sure with the one vote. I wanted to confirm
Just the one? You're all set? Thank
See you
you.
soon. Thank you, bye.
Senator Lesser?
Senator Lester, yes.
Okay, thank you so much. And Representative Quinn?
Representative Quinn, yes.
Excellent. Thank you so much.
Yes.
Hi, Representative. You're muted. You're muted. Here we go.
Okay.
Okay, how would you like to vote on House Resolution 5?
Yes, I think. Yes.
You're all set.
Wait a minute, there were
Just
two
the one.
though. There was,
There's two, we have them split as a Senate resolution and a House resolution for the settlements.
oh, that's,
So
okay.
just one.
And can I ask a question? Has mostly everybody voted?
Say that one more time?
Has mostly everybody voted?
Yes. Yep, we're almost done. Holding votes open until 12, and then we've got the hearing at 1.
And then we're having a hearing at 1.
That's right. Yep.
Okay, I got it. Thank you.
Of course. You see that?
Okay, bye-bye.
Hi, Representative.
Hi,
How would you like to vote for House Resolution 5?
a yes.
All right, you're all set. That was it. Thanks so
Oh,
much.
that's the only vote?
Yep, that was it for now.
Okay, thank you.
You got it. Right.
Hi, Representative Godfrey.
There, oh, come on.
I just saw you there.
There, that's better.
Okay, so we have, the resolutions are split by chamber. So for House Resolution 5, how would you like to vote?
Yes.
Okay, that's the only thing we have for today. And then we've got the hearing at 1.
Is it a hearing at one or a hearing in a meeting? Remind me, please.
Just the hearing at 1. Yep.
And it's on the claims?
Yep, we've got 4 wrongful incarceration claims or awards, and then we've got extensions. Yep.
Okay, very
right.
good. I'm actually just getting ready to leave Danbury. I'm coming in, so I'll see you in a little while.
Perfect. Yeah, we'll see you in a bit. Drive safe.
Take care. Thank you.
Thank you. Hi, Senator Mar. Oh, yeah, actually, I heard something. What are you gonna Can you hear me? Oh, there you go. You're muted. One sec. Oh, I can't do it. Okay, sorry. No, you're okay. So we split the resolutions by chamber. So for Senate Resolution 5, how would you like to vote?
Vote yes.
Okay, excellent. That's all I need.
That's it. Okay, cool. Thank
you so much. Take care.
Okay, bye. Hi, Representative.
Sorry about that.
No, no worries, but I got you. So we've got one vote for today. It's House Resolution 5. How would you like to vote?
Representative Curry votes yes.
Excellent. Thank you so much.
Take care.
You too.
Hi, Madam Clerk.
Hi,
I mean,
Senator.
Madam
How are you?
Administrator, please excuse me.
It's all right. So we have one vote today, Senate Resolution 5. How would you like to vote?
I would like to vote yes.
All right, you're all set. That's it.
Thank you.
You got
Have
it.
a nice weekend.
You too. Hi, Senator.
I'm trying to come on. My computer's acting
It
strange
seems we've
today.
had that with a few people this morning. No worries.
Yeah, hold on for 1 second. I don't know. She doesn't want to act right. Oh, I just shut it off.
Oh,
Okay,
there.
there I am.
Perfect.
Hi.
How are you?
Good. How are you?
Good. So we have one vote today. We split the settlement into two separate resolutions. So for Senate Resolution 5, how would you like to vote?
Yes.
All right. That's it. You're all set.
Yeah. Thank you. Have a nice weekend.
You too. Take care.
Bye.
Kirsten?
Hey, your representative. How are you?
Good, how are you?
Good. So we've got one vote today on House Resolution 5. How would you like to vote?
Yes.
All right. You're all set.
Thank you. And then we have 1 o'clock.
Yep. We got a public
Hearing.
hearing at 1.
Thank
That's right.
you.
You got
Okay.
it.
Bye.
Hi, Representative, how are you?
Good morning.
So we have one vote. We split the resolutions by chamber. So for House
Yes.
Resolution 5, how would you like to vote?
Yes. Tomato votes yes.
Excellent. Thank you so much.
Was that for me or the other person? Sorry.
You, Representative.
Okay, thank you.
You're all set. You're welcome. And Senator Gaston, how are you?
Hello, how are you? Senator Gaston votes yes.
Excellent. You're all set. It's just the one.
Thank you.
Take care.
Take care. Bye-bye.